All right, everybody, this is the promised daily update in the Fani, Willis, Nathan Wade judicial saga of the disqualification of the district attorney and special prosecutor. Closing arguments, people. And it was painful. Now, before we even get into the summary of the closing arguments, I had on the show as a guest before the live hearing, Phil Holloway, who is a Georgia attorney, was an amazingly insightful man to have on the channel, has been following this case thoroughly. And we were talking about what he thinks the outcome is going to be. And I asked him whether or not he thought that the fact that the judge, Scott McAfee, is up for re-election for a full 4-year term because he was recently appointed to fill a vacancy, whether or not that would have an impact on his decision-making in this case. And Phil Holloway had a very interesting insight. He mentioned that Scott McAfee is up for re-election, and thus far nobody's challenging him in his district, in his seat, however it works, because there's a window time frame within which if you don't announce that you're running for election, well, Scott McAfee might discover that he's running alone, in which case he gets nominated by acclamation. Is that the word? You know what I mean? He gets nominated because nobody's running against him. That window to announce your candidacy to run apparently expires soon, this month, in March. And so I said, well, that's interesting. So he'll take his time to render the decision so as not to rock any boat, entice any activist to run in his seat. He's up for re-election, or he's up for election for a full 4-year term in May.
Yes.
How do you think that influences his decision-making in this case?
Well, that's an excellent question. All right, so there's nobody currently that has announced that they're running against him that I know of. I've been asking around. I've been keeping my ear to the ground to see if anybody's coming out. Nobody's announced that they're running against Willis either. Qualifying, you got to qualify, and pay your money and all that to get on the ballot. That's this month. It's later on in March. And it's like a week. It might be 2 weeks. I forget, but people can research it and figure it out. It's a limited window of time. And a lot of judges who are unopposed, they literally are like they're just watching to see if somebody at the last minute throws their hat into the ring to run against them. And once qualifying's over, they can breathe a sigh of relief if nobody runs against them. So we just don't know. If it stands the way it is now, and he has no opposition, then he'll start his own 4-year term next year.
Well, I would say strategically, then what he might do is take 2 or 3 weeks to draft a decision.
I think, a Senate could look at it that way. But the thing is, it's going to take him a while anyway.
The bottom line and just the punchline of all of it is that Scott McAfee said he expects that it should take him a couple of weeks to issue his decision because he's got to consider issues of fact, issues of law, yada, yada, yada. Get over here. All right. That's the punchline of the outcome. There was no decision from the bench. I don't think anybody was expecting a decision from the bench. Probably the most unlikely of unlikely outcomes. So Scott McAfee said, I'm going to take everything under deliberation. I'll have a decision within a couple of weeks. The day, however, started off with a little bit of drama because one of the lawyers for the defense for the RICO case people, Trump, Michael Roman, I forget who he represented, might have been Giuliani. It doesn't really matter. One of the attorneys for the defense says, we'd like to reopen the evidence because we've come across new evidence that we think should be adduced for the purposes of Your Honor's rendering his decision. We didn't know what it was. We still technically don't know what it was in the court because the judge said, no, we're not really opening new evidence. If you have to do it later, make your closing arguments today. But I have a little birdie as to what this new evidence was. And it turns out that it's an affidavit or a voicemail from a waiter at a restaurant who said, I'm watching this trial and I was watching Terrence Bradley testify that he had not seen or spoken to Nathan Wade within the last 2 years. I'm a waiter at a Georgia restaurant somewhere in the center, in the area. And I just served Nathan Wade, Bradley, and someone else, I forget the person's name, in the file 5 weeks ago. Nathan Wade sat Terrence Bradley down for a lunch upwards of 5 weeks ago, give or take. And I'm sure that they had a discussion in which Nathan Wade made Terrence Bradley an offer he could not refuse so as to ensure his future cooperation and future amnesia. I have no doubt they sat down and said, remember that alleged incident of sexual assault with that employee where you paid them 20 G's out of your escrow account? Well, we can probably see that turns into a criminal prosecution if you don't forget real quick what you told Ashley Merchant in those text messages. So that was the drama of the day. The judge said, didn't even hear any of this in open court because they never got into to the evidence that the lawyer wanted to adduce, but Megyn Kelly got her hands on the recording, as did I, but I was a little reluctant to publish the recording until I could be assured that it was in fact public or for public consumption, and that I wouldn't be secretly disclosing an exhibit that wasn't public. But I did get a hold of the recording, and I published it to our vivabarneslaw.locals.com community, and then to Twitter afterwards. Here's the recording.
Hey, Ashley. I'm calling. So I just watched the Terrence Bradley hearing, and I noticed on there he said that he hasn't talked to Nathan Wade in 2 years. But I work at a restaurant here on the square, and I waited on Terrence, BC Chopper, and Nathan Wade about 5 weeks ago. So I just saw that and thought maybe you should know that if you want to call me back.
And the state also had some evidence that they wanted to introduce, an affidavit from some dude in the Napa winery testifying to the fact that he remembers Fani Wade paying him $400 in cash when she was down there with Nathan Wade for the wine tasting tour. Such a pathetic act of desperation.
Let me do one thing before we get started. I'll put this on mute for the time being. There was an additional affidavit filed today, people. Fani Willis, in full meltdown mode, filed an affidavit from some dude in Napa Valley who testifies to the fact that he remembers her paying cash, $400 cash for some Grey Goose. Not for some Grey Goose. Look at this. Notice of file. This is from state of Georgia, yada, yada, yada. Who's this? Notice of filing state's proposed supplemental exhibit 1 to the hearing on defendant's motion to disqualify. Comes now. That's probably not the best way for Fani Willis to start, or Nathan Wade to start. I'm joking. That's how they start all of them. State of Georgia, by and through Fulton County, District Attorney Fani Willis, etc., files this proposed supplemental exhibit 1 to the hearing on defendant's motion to disqualify. Proposed supplemental exhibit 1 consists of an affidavit from Stanley Herbert Brody, asserting 1, that on April or May 2023, Brody was working at the Acumen Wine Gallery in Napa, California. 2, that Brody greeted and met with District Attorney Willis and Special Prosecutor Wade at the Acumen Wine Gallery, that they got drunk and misbehaved, just joking, that Brody exchanged pleasantries, spoke about wine, tasted wine, and discussed his profession with District Attorney Willis and Special Prosecutor Wade. And 4, that District Attorney Willis paid the bill for the tasting with approximately $400 cash. That affidavit is attached to the state's proposed supplemental exhibit 1. Mr. Brody is available to testify at the court's convenience. Oh, yeah, because it's totally relevant that at some point in Fani's life, she did in fact pay for cash. Like, that's the disputed fact here. Oh, it's an act of sheer desperation, people. We found a guy that says he paid cash. She paid cash. Amazing.
As though that would prove anything. As though what was at issue was that Fani Wade never paid for anything in cash. No, that was not what was at issue. But the funny thing is they can find someone to testify to the fact that she paid for something in cash, $400 at a winery, but couldn't find any evidence of actual reimbursement of cash from Fani Willis to Nathan Wade. The state just doesn't understand when they're raising arguments that actually undermine their own position, as testified to, or at least pleaded by whatever the guy's first name is, Abate, when he made closing arguments for the state and Fani Willis. It was pathetic. But before we get there, that was the intro drama. Then we got into a little bit of the boring pleadings. It's closing arguments, people. They're going to plead the law. At first, you had Merchant's husband, I think his name is John Merchant, pleading the law. He had 20 minutes. He talked about the applicable case law, yada, yada, yada. Not the most enthralling thing on earth. Then you had Trump attorney Sadow come in, and he was damn good, but not the best. The best lawyer for the defense arguing for the disqualification of Fani Wade and Nathan Willis. I keep doing that. Fani Willis and Nathan Wade. I don't know which lawyer it was. He was amazing, and he basically said to Scott McAfee, the whole freaking system is on trial right now. We are a laughingstock of the international community because of what the world has seen transpire in this courtroom, because of what the DA has been doing in this file. It's a laughingstock, it's a joke, it's an insult. It's not just a conflict of interest. It's not just wildly improper conduct. It's a joke, and America, the American legal court system, is on trial here, and the international community is laughing its heads off. You know what to do, Scott McAfee.
The problem here is the DA cannot distinguish between her personal interests and ambitions on the one hand and her public duties as a prosecutor on the other, and apparently neither can anyone else in their office. Of the 6 conflicts I've identified, only 1 is subject to a conflict in the evidence. This is a case study in what happens when you operate under a conflict of interest. it's put an irreparable stain on the case. Think of the message that would be sent if they were not disqualified. If this is tolerated, we'll get more of it. This office is a global laughingstock because of their conduct.
Yes. Testify, whoever you... What's this guy? What's his name? Yes.
The defense, that being Trump, Michael Roman, who brought this motion through, Ashley Merchant, Giuliani, etc., they raised the arguments that there's not just an actual conflict of interest, there's at the very least an appearance of conflict of interest for obvious reasons. They actually argued that Fani Willis and Nathan Wade should be disqualified, not just for the appearance of conflict of interest, which is patent, apparent, almost undeniable, as is the actual conflict of interest, but because of the, what do they call it, forensic misconduct, that because of what Fani Willis did outside the court, going to the church, claiming racism, impugning the names and the reputations of the defendants in an ongoing trial, that was forensic misconduct that also warrants Fani Willis and Nathan Wade being disqualified from the case. And they went hard on that. Fani Willis gets up in front of a church, in front of the pulpit of God, and argues that the only reason anybody's going after her is because of race. Because her boyfriend, although she didn't admit that she was actually having the illicit extramarital affair with Nathan Wade in front of that church, she argued in front of the church that the only reason the big bad people were going after Nathan Wade was because he was black. It is outrageous. It's egregious. Hold on. It's preposterous, and everyone in that church gallery should be offended, outraged. So then, after all of the respective attorneys for the defendants had their kick at the can, it went over to Abate. It was an hour and a quarter of the most painful flubbing around. It was a joke. I mean, it was straight out of Billy Madison. Billy Madison's speech on the Industrial Revolution and the puppy that lost his way made more sense than what Abate was arguing in support of maintaining Fani Willis and Nathan Wade in the case. The guy couldn't keep a coherent thought. He said more ums and than Justin Trudeau on steroids. He was flip-flopping back and forth, misrepresenting the law, saying that the only law that applied here is an actual conflict of interest and not the mere appearance of conflict of interest. He was submitting case law to the judge that was actually disproving his own theories while misrepresenting that case law to the judge, but the judge knew better.
And so, getting into the language again, what you just had up there with greater amusements and amusement sales. Greater amusements is one of those. You refer to the appearance of conflict as dicta. Why do you think that's dicta? I think the quote from that one is, it guarantees at least the appearance of a conflict of interest. Why is that dicta? It seems very central to the holding in the case.
Because I don't disagree with Your Honor, but in that case,
I'm just trying to mislead you.
Conflict was found, and the appearance.
They didn't find that.
I would disagree with Your Honor. My reading of the case is that an actual conflict was found, but because of that actual conflict, an appearance of impropriety was seen, and that's the reference.
This is impossibly bad.
Reference of that case in relation to the argument that an actual conflict is required.
This is impossibly bad, people. He's misrepresenting the cases, misrepresenting the law,
series of cases,
and misrepresenting the facts.
It was a joke, and it would have been funny if it weren't so damn sad. The guy's sitting there, his hands, he's clinging to the table, because I swear to you, I thought he was going to faint. I thought he was going to pass out. At some point, someone on Fani Willis's team came up and gave a note to Abate, and I gotta tell you, I don't know if that note said you're fired or you're going to be fired immediately after you finish embarrassing Fani Willis, but he got 2 notes. He was flustered. It was terrible. Just 0 on 10. And the jokes in the chat are flowing like the wine at the winery where Fani Willis was off with Nathan Wade paying $400 in cash for wine. The jokes in the chat were relentless. And I'm thinking, who the heck is this lawyer? Is he a first-year lawyer? And the internet is an amazing thing. I found a decision which referenced the lawyer Abate. And here's an excerpt from that decision which shows you not just the capabilities of this lawyer, but the ethics as well.
And if you Google Abate, you'll find a decision in which Abate's name comes up. Set aside the context. I'll give the link is in the tweet. At the hearing on the motion, Glenn testified as follows. At the time of Thomas's trial, she had a pending shoplifting charge from Carroll County, which would be a felony because of her prior shoplifting convictions. The prosecutor who tried Thomas's case, Fulton County Assistant District Attorney Adam Abate, came to her house with an investigator about 2 weeks before the trial to ask them about her Altima. I guess that's the car. Glenn told Abate that she did not remember if Thomas had the Altima on the night of the murder. Abate told her that if she did not cooperate, she and her mother would be subpoenaed. Fine. After that interview, Glenn talked to the attorney representing her on the shoplifting charge and decided to meet with a prosecutor again. She talked to Abate at the courthouse during Thomas's trial. During that discussion, Abate noted that he was aware of Glenn's pending felony charge and said, quote, "I'm sure you don't want to go to jail," end quote. He then told Glenn that if she answered the state's questions, quote, "as they wanted her to answer them, then her case will go away." On cross-examination at the hearing, Glenn testified that her trial testimony was not true, but she did not provide more details. That's who we're dealing with in terms of Abate, the lawyer who you just saw not skate, who you just saw fall through the ice and struggle to break the ice from underneath for 2 hours.
Fulton County District Attorney, he went to a witness and said, "You're going to go to jail if you don't answer the questions the way we want you to, and go ahead and testify." There's a word for that, and I think it's called suborning perjury. I'm not sure. I'm not making any accusations. I'm just reading from a decision. Answer the questions the way we want you to, and you won't go to jail. Gee, I wonder who else they said that to. Maybe Terrence Bradley? And this corrupt idiot nincompoop Abate, I mean, he was sucking and blowing at the same time. He didn't know which way he was going, front or back, flip-flopping this way and that, just making arguments left, right, and center. Oh, it's not the appearance of conflict. It's an actual conflict of interest, but only in the result of the prosecution itself. My goodness, he was trying to hone down, define in a way that is not the legal definition, conflict of interest, so that what we now know is an obvious conflict of interest as relates to Fani Willis's conduct in this. Well, it really wasn't a conflict of interest, but only merely perhaps an appearance of conflict of interest because, Fani Willis had no vested interest in the outcome of the trial. Now that she's no longer dating Nathan Wade, I guess she doesn't have a conflict of interest anymore, maybe. Although he was trying to argue that Fani Willis didn't actually have an actual conflict of interest because she had no vested interest in the outcome of the case, as if that's the criteria, as if Fani Willis didn't benefit by hiring her boyfriend, siphoning $600 and some odd thousand of taxpayer dollars to her boyfriend without disclosing it, bypassing the requirements by law, as far as I understand, or ethics under Georgia law, so that she could then bestow onto herself travel, gifts, cruises, wine tasting things. Oh, no. But she paid him back for all of that except an admitted amount of at least $9,200. She had no conflict of interest. She had no appearance of conflict of interest. It was just verbal diarrhea for about an hour and a quarter. And then at one point, in an attempt to, mitigate the cell data information, he was saying, oh, these two were allegedly involved in a relationship, and yet we have no cell records, data records of Nathan Wade visiting Fani Willis's house, the one where her father was staying because it was so dangerous. We have no records of that, which is totally unlikely given that they were allegedly involved in a several years serious relationship, not understanding that the evidence of the case itself from Fani Willis's testimony to her father's contradicted that very argument. Fani Willis said, "I'm a very private person and we kept this private." Fani Willis's father said, "We never saw him. I never knew that she was dating him until 7 weeks ago when all of this broke." And so what you have is Abate saying, there's no evidence of a serious relationship here where you would expect to see Nathan Wade showing up at Fani Willis's house, because they specifically said we kept it secret, and so secret that even when they were admittedly dating, admittedly knocking the booties, even then Fani Willis's father didn't know. He only discovered it from the news 7 weeks ago. I mean, it looked like this lawyer not only did not prepare for his closing arguments, it looked like he didn't even attend the trial. I swear to you, I could have done a better closing argument than this guy, and I would have probably kept it to 15 minutes, because when you see opposing counsel laughing as you're pleading, when you see the judge basically put down his pen, start shuffling his papers, he was basically asking Abate, are you done? Do you need me to put you out of your misery? Do you want me to tell you to stop? Because you're digging a hole so deep, my goodness, keep digging. Maybe you'll get on your next cruise with Fani Willis in Australia. So that's it. That's the summary. I hear my kid, and I don't know what movie he put on TV, but I said, put on whatever you want, and I'm going to do this video, and then we're going to make a barbecue, a tomahawk steak. That's the latest. 2 weeks, give or take. I think it's going to be a little more than 2 weeks. Scott McAfee's going to come down with his decision. I am standing by my prediction. Fani Willis, Nathan Wade are getting booted from this file. I don't think they're going to dismiss the indictment. They'll find another district attorney from another county to see if anybody in their right mind wants to take this file on any longer. But we'll see. That's my prediction. You know what to do. If you like my stuff, like, share, subscribe, hit the notification bell, drop a comment in the comment section. Viva Frei on Rumble, Viva Frei on Twitter, vivabarneslaw.locals.com, and we will be talking about it Sunday night, sure as sugar, with Robert Barnes. We will also talk about the recent developments in the Amish Amos Miller persecution out of Pennsylvania. But, that's it. Go. Enjoy the weekend. Enjoy the night. Peace out. Booyah!
Why
How do
she's
you
not living.
reconcile that with this testimony that was alluded to, I think, by
His father.
opposing counsel, the reasons he gave for being in the area?
Well,
Would those line up to 23 times? I think,
well,
I didn't give too many reasons for being there, right?
Well, I think that's the point. I would say yes, that is the point. He referenced that that's an area that it was not uncommon for him to be in, and clearly that is the case because Miss Willis didn't live in that area.
I could destroy him in cross.
As to what Mr. Wade indicated to the court. And when, I guess after Miss Willis moved into the condo
planning to
in
murder
April
him.
of 2021, they appeared 35 times. Now, I want to make clear to the court, both Miss Willis and Mr. Wade never denied that he had been to that condo before. The specific testimony that was elicited by Miss Willis and Mr. Wade was that he had never laid his head